Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now, take a look at this. Analisa Torres, the judge who gave Ripple and XRP hope in July of last year, federal judge Analisa, Torres gave the cryptocurrency industry a boost by granting Ripple a partial victory in its battle against the United States Securities and Exchange Commission. This victory was a significant step forward for the industry. Judge Torres concluded that although Ripple had violated federal securities law by selling XRP directly to institutional clients, it had not done so by placing XRP on exchanges for regular users to acquire. This profile is included in the list of the most influential 2023 on CoinDesk. The cryptocurrency sector and the Securities and Exchange Commission can't seem to agree on how exactly federal securities regulations should be applied to digital assets. In the absence of legislation from Congress that could establish so-called bright lines guidance or construct a safe harbor for token issuers and trading platforms alike, the United States judicial system has been tasked with determining whether or not the explanation provided by the Securities and Exchange Commission is accurate, or whether or not businesses have a point when they assert that the laws that are currently in effect are out of date and inappropriate. At the question is more than just an academic. If an asset is considered a security, the issuer of that asset is subject to stringent disclosure and registration rules in the United States. Cryptocurrency companies argue that digital asset issuers can't comply with these rules because of the very nature of decentralized and disintermediated tokens. Trading platforms that list those assets are also subject to a stringent regulatory environment, which is comparable to the regulatory framework that governs their traditional financial counterpart. Additionally, if an asset is not considered a security, then things are a great deal simpler for all of these businesses. The District Court for the Southern District of New York, which is now supervising around a dozen crypto proceedings, including numerous claims brought by the Securities and Exchange Commission, is the jurisdiction in which this subject is even more significant than it is elsewhere, because Judge Torres ruled that Ripple had legally sold XRP to retail investors and may continue to offer XRP to retail investors through blind bid-hack sales on exchanges. This verdict has the potential to establish a precedent that the industry can return to on multiple occasions. Programmatic buyers could not have known if their payments of money went to Ripple or any other seller of XRP. The judge noted in his decision, an overwhelming majority of individuals who bought XRP from digital asset exchanges did not invest any of their money in Ripple in any way, even though an institutional buyer made a conscious purchase of XRP directly from Ripple by a contract. The economic truth is that a programmatic buyer was in the same position as a secondary market purchaser who was unaware of who or what it was paying its money to. An example of it is dependent on the decision caused shockwaves to travel across the business, but it also prompted issues regarding the kind of precedent that it established. The decision was obviously very beneficial for exchanges in particular, said Grant Glovson, an attorney who represents clients who are involved in the cryptocurrency marketplace. The degree to which the decision will be beneficial to cryptocurrency businesses and initiatives, on the other hand, really depends. The verdict is currently being made in a single courtroom within a single court, and is quite evident that the Securities and Exchange Commission plans to appeal it once the overall matter has been resolved, in what appears to be an effort to expedite the appeal process. The regulatory body has already done away with the allegations that were brought against Ripple executives Brad Garlinghouse and Chris Larson. If the ruling is adopted by the Court of Appeals, it potentially provides a pathway for projects to raise funds, Glovson explained to reporters. Moreover, the decision made by Judge Torres might turn out to be an anomaly. In a summary judgment ruling of his own in the SEC's case against Terraform Labs, Judge Jed Rakoff, another judge in the same court explicitly rejected Judge Torres' analysis. However, it is important to note that obviously the circumstances of that ruling are unique to that case, just as the circumstances of the Ripple ruling are unique to this case. It could take some time to receive a ruling from the Court of Appeals. The Securities and Exchange Commission is unable to file an appeal until the matter has been resolved, as Judge Torres has established a schedule for some extra proceedings that will continue until April 2024. Ripple's chief executive officer, Brad Garlinghouse, has dropped hints about a significant shift in the ongoing legal battle with the Securities and Exchange Commission issue. He suggested that a showdown might be on the horizon, which caused a buzz about the possibility of an agreement or a significant conclusion. Experts in the field of cryptocurrency law responded to this tweet almost immediately. The euphoria is referred to be nonsense by Bill Morgan, a specialist in crypto legal matters. According to him, a settlement meeting indicates that the legal struggle has already been resolved. He takes the time to emphasize that a settlement is not the same thing as a spectacular showdown. This is because it requires compromise with agreement on certain aspects being reached by both parties, opportunities for settlement, and obstacles to overcome. Morgan thinks that a settlement is not likely at this time. He makes the point that disagreements are typically resolved through settlements, which includes the opportunity to appeal, which could be a significant cause for concern. There is a possibility that the actual impacts of a settlement will be more extensive than what is now being discussed. It is possible that Ripple's XRP sales after December 2020 and any subsequent sales could be impacted. Some of the money that is currently sitting in that infrastructure, the actual liquidity that enables you to trade, has not yet flowed into the cryptocurrency space. This is simply because the cryptocurrency area is still relatively new and in its early stages. The fact that we are attempting to provide our payment customers with a terrific customer experience while also providing them with a highly dependable cross-border payment at a cheap cost is one of the challenges that we are facing. During our journey, we have been required to develop our liquidity trading platforms, integrations, collaborations, and compliance services. This has required us to go deep into the realm of liquidity management. It is terrible that many people in the sector did not make the effort to perform these things correctly because they need time. However, if you have those items, you will be able to look at them and say, hey, today we can solve a cross-border payment for a remittance company. There is a possibility that a new business intends to sell luxury items and is considering the possibility of accepting stable coins or providing non-fungible tokens, NF, for their consumers to be able to bridge the gap between the fiat system and the digital asset system. They will have similar requirements to manage liquidity and access the cryptocurrency liquidity now available. It has been my privilege to take charge of and accept responsibility for the infrastructure that we develop for payments, while also acknowledging that it is the basic architecture for other components and commercial use cases. This serves as our blueprint because we are still relatively new. There are a lot of different components that as you work through a particular use case, you realize, oh, the next use case is going to require a little bit of this along with it. Consequently, warning, the information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional